Excuse me. All right. Sorry, we have to wait for it to get started. Otherwise, it's going to come on while we're on the record and it creates an enormous amount of feedback. Okay. Now, yes, is this the, here we go. Ms. Velasquez, is that you?
Yes, ma'am.
Excellent. Who is that attorney on this one?
That's me, Judge Zach Runyon.
Excellent. Ms. Peterson, are you on that one as well?
I am, Your Honor. Thank you.
Okay, are we ready to go?
Yes.
Perfect. All right, last bit of housekeeping. I gotta start recording. Okay, calling case number 23-015138. Ricardo Velasquez and Marlene Velasquez as next friend for Elijah Pashal. Appearances, please.
Morning, Zach Runyon on behalf of plaintiffs.
Good morning, Your Honor. Nikki Peterson here on behalf of defendant State Farm.
Okay, and I see Elijah there as well. Okay, Ms. Velasquez, can you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide in this case will be the truth?
Yes, ma'am.
Okay, go ahead, Mr. Runyon.
Thank you. Ms. Velasquez, are you the mother of Elijah Pascal?
Yes.
Okay, and in this case, you're acting as his next friend?
I didn't hear you. What'd you say?
I said in this case, you have been nominated as Elijah's next friend?
Yes.
Okay, and you're aware that State Farm has offered to settle Elijah's PIP benefits through today's date for $20,000?
Yes.
Okay, and you understand that if Elijah needs medical care or other services related to the motor vehicle crash moving forward, he'd still be able to claim those from State Farm?
Yes.
Okay. And do you understand that if you accept the settlement, or if the settlement today is approved, you will not be able to go back and ask State Farm to pay other medical benefits that occurred prior to today's date? Do you understand that?
Yes.
Okay. And the outstanding bills that Elijah currently has are from University Physicians, VHS, Children's Hospital, Spectrum Health, Wellspring Case Management. Do you understand that if the settlement's approved, those providers will be paid for their outstanding bills?
Yes.
Okay. And you understand that an amount would be going to you as his attendant care and household replacement services provider?
Yes.
Okay. Do you understand that if you went to trial in this matter, you could receive a higher amount, a lesser amount, or the same amount?
Yes.
Okay. Understanding that, do you want the settlement to be approved, and do you believe it's in Elijah's best interest?
Yes, sir.
Okay. Judge, I have no further questions.
Okay, Elijah, I'm going to ask to unmute you. Do you see a prompt there? Hey, good morning. How are you?
Good, yeah.
I'm doing okay. What's your name?
Elijah Pascal,
Elijah, how old are you?
15.
Okay. All right. Do you understand that we're settling this case for services and PIP benefits through today's date? Do you understand that?
Yes.
Okay. And if you continue to have treatment in the future, you can go back and pursue any bills that you might have against State Farm. Do you understand that?
Yes.
Okay. What was injured in this case?
My head.
Your head?
Yes.
Okay. Do you, excuse me, as of now, do you anticipate any continuing treatment? Do you have any doctor's appointments in the future that you're aware of?
No, not that I'm aware of.
Okay. All right. Where are you right now? Where are you right now, physically?
Home.
Yeah, home.
Oh, home. I thought he said, sorry. Okay. All right. Ms. Peterson, do you have anything?
I do not have anything, Your Honor.
Okay. All right. Everything appears to be in order, Mr. Runyon. Your motion's granted. Settlement's approved. Get the documents into the court.
Thank you,
Thank
Judge.
you, everyone. Yep.
Thank you.
Yep. Take care. You guys can log off now.
Thank you.
Marlene,
Have
thanks
a
for
good one.
Thank
Yeah.
you. Mr. Broderick, what case are you here for? I don't know if you came in a little late. I don't know if you got the announcement unless we have, unless you received a notice from the court saying you have oral argument today. There's no oral argument. And from what I could tell from the docket sheet, there looked like there was only about 4 up at 9 a.m. So with that,
So Judge, Ms. Chiquita Palmieri Bryant and I are popping in because we have an evidentiary hearing with you today.
oh, yes, thank you. Okay, what's going on with that? I did plan on contacting you. It was kind of a surprise to me. This date snuck up. What's going on?
We would like to adjourn. We set up this opposing counsel and I set up some hard dates yesterday to meet and try and resolve this case, exchange the medicals and stuff. And with my daughter's wedding and doctors fighting about
Hey, say no more. Say no more. I am glad that you guys showed up. Okay, what's your proposal? What do you want to do with this one?
I would say put it out, 30, 45 days?
Yeah, about 45 days would be good for me. So if we don't resolve it, then that'll give me time to resubpoena the doctors, get on their schedule,
Yep.
which is always hard. So if we can have at least 45 days, I think Attorney Broderick and I are committed to beating each other up in the month of July so that we can probably resolve this.
Do you guys want to just submit a stip and order with whatever provisions you want? And I can give you another evidentiary hearing date we're looking at today's the 27th. My last date, it would be, would August 8th be good? I think that's probably right around the 45-day mark. August 8th at like 1 p.m.
1 p.m. August 8th at 1 p.m. works for me.
All right, why don't you submit an order then? And if you guys have any other provisions that you want to put in there with respect to how you move forward, go right ahead and do that.
Okay.
Okay.
Thank you so
Thank you,
much.
Thank you so much.
Okay.
All right, bye-bye.
Bye-bye. Have a good
Okay,
day. Thank
goodbye.
you.
Ms. Pearson, that was case number 23-010386. Ian Jones versus John Doe. All right, Mr. Klein, good morning.
Good morning, Judge. I have a feeling that my case had the hearing waived, but Your Honor said 9 o'clock, and I just wanted to make sure that I didn't miss something because
That's fine. I understand. No,
on the docket it said 8:30. I was
Yep.
logged in, but I wasn't let in. Are we good?
if it was an 8:30 a.m. hearing, it's being decided on the pleadings.
Excellent. Thank you, Judge. Have a wonderful weekend.
You too. All right, Mr. Turfy. Which one? I'm looking.
Your Honor,
Good morning, Your Honor.
I'm here on with Mr. Turpy.
Kamaj?
Okay. Is this Kamaj?
It is, Your Honor.
Okay. Perfect. Unfortunately, you're gonna have to give me a minute because this one was not printed up for me. I think it might have been adjourned from last week.
It was.
So, okay. My apologies. I had a family emergency last week and I was
No
unable to
worries.
Friday morning docket, so I'm just looking. Here we go. All right. Calling case number 24-011680, Martin Kamaj versus Alan Rostam. Appearances, please.
Good morning, Your Honor. Ed Turfy for plaintiff.
And good morning, Your Honor. Good morning to your staff and everybody here. Hassan Hamadi on behalf of Bruce Rustam.
Okay, go ahead, Mr. Turfy. This is your motion.
Your Honor, this is the first discovery motion for sanctions that I've filed in probably 20 years. This case, as the court knows, is about a loan that was never repaid. It's plaintiff's contention that defendant Bruce Rostam duped him into loaning money to him and his father under false pretenses. The court's already granted summary disposition in favor of plaintiff against the father, defendant Alan Rostam.
Mhm.
But during discovery, there's a couple things that came out. For example, defendant Bruce Rostam claimed that he had no financial interest in the deal that was the basis of the loan for his father. And when I took the deposition of his wife, I asked, did you give any money to your father-in-law for this deal? She says yes, we gave about a 1.2 to 1.3 million dollars. So I sent a follow-up interrogatory asking for evidence of the loan made from one defendant to the other. They objected and said it's not reasonably calculated to lead to any discoverable evidence. There's no basis for that objection. Also, one issue in this case is the loan from my client was secured purportedly by two purchase agreements claimed to have been signed by defendant Alan Rostam. However, our contention is that defendant Bruce Rostam actually signed Alan's name. In fact, defendant Alan Rostam testified to that fact. I asked defendant Bruce Rostam's wife if she's ever seen Bruce sign Alan's name to anything. She says yes, maybe 14 years ago when we took over the business, he signed his name to some checks. So I asked for the names of the bank accounts so that I can get some of the checks to compare how Bruce signs Alan's name compared to what it looks like on the purchase agreements that support the loan. Again, they objected, providing absolutely no information whatsoever. Your Honor, I could go on. This is how they objected to every question. They provided zero information, and I've been more than willing to work with them on this. But this all started. This interrogatory was sent, I think, in February. When it was late, I called them and asked for concurrence rather than file a motion. They agreed. They said, we'll enter a stipulated order. So they prepared an order. They changed the one that I sent and asked me if I agreed. I said, yeah, that's fine, file it. And they said they'd file it. Well, a month goes by or 3 weeks goes by and they don't file it. So I call them again. I said, why didn't you enter this order? So they gave me some song and dance, and then they entered it a week later. So this is just obstructionist at its finest. I've never seen anything like this. And frankly, Your Honor, as I said, this is the first motion asking for sanctions that I've filed in 20 years. I think it's wrong.
Mr. Turfy, let's try to resolve this the best way I can. What are you still looking for despite their objections? So you want documents related to the loan, and you want checks from the bank, and what else?
Well, I don't know that they have any documents related to the bank accounts. I would assume that I'd have to get them through subpoena. So I at least need them to identify the bank accounts.
Okay.
They'd have to identify the bank accounts. I want any documents that substantiate the claim that they sent the other defendant $1.2 to $1.3 million.
Yep,
Together with any other monies that may have been sent. I mean, I only know of the $1.2, $1.3 million. And Your Honor, it's a broad question because the defendant and his wife, they own several businesses. So it's directly or indirectly, whether it's one of their business accounts that they sent it out of or one of their personal accounts, I want that information, and then I want to know all the business entities that they own. I mean, when I asked them the question, they told me that they own two businesses, or defendant told me he owns two businesses. But if you go on to Lara, he's listed on like 12 businesses. So this is all moving. Everything's moving in this case in terms of facts. And it's like having an argument with somebody of who's the better basketball player, Michael Jordan or Kobe Bryant. And there's no record, there's no substantiation to any of it. It's just you just say something and that's what you got to go with. So I'm seeking information, as I put forth in the interrogatories and requests for documents, that substantiate their claims or disprove their claims. And they've
Do you
just
have
stonewalled me.
specific interrogatories that these relate to?
Absolutely. These are
so that you can craft an order. Mr. Hamadi, why don't you just submit supplemental? I mean, especially if you agree to an order, why don't you just submit supplemental responses to the interrogatories rather than object? He's going to get his discovery.
So, Your Honor, you're familiar with our firm. We're not here to play games. We're not here to obstruct. We don't do personal injury. So, maybe in 20 years, he hasn't filed any sanctions, but what I'm telling you is we don't do this motion, stuff with other attorneys. I will be very clear with you. Our client, this word directly or indirectly doesn't hold any weight, right? Here, this is a fishing expedition, right? He cannot provide bank accounts from 14 years ago because he doesn't know bank accounts from 14 years ago. Mr. Turfy doesn't like that answer. Well, guess what? That's the answer you're going to get because really he doesn't know what the bank accounts from 14 years ago. And the wife didn't testify, Your Honor. She did not testify. She said he may have signed some checks over 14 years ago, but hasn't done since yet. Mr. Turfy has failed to tell you he has the loan documents for the $1.2 million that were given, right? He has them. Why? Because they were provided, not by us. He has the $1.2 million bank accounts. But I'll tell you, that is not relevant in this case. Why? Because there's only two allegations made against our client. And I don't want to beat a dead horse, and we're not here at trial for the case, but it's only the marketability of the property used for collateral, one, and that he alleges he forged his dad's name or signed his dad's name. Those are the only two options. What he gave his father after the fact, whether it's $1 or $1 million, has no relevance. What Mr. Turfy's trying to do, I was about to say Judge Turfy, what Mr. Turfy's about to do is he wants to find out what businesses this guy owns, that if this court finds, or in a trial, if a jury or Your Honor finds that he's liable and he's part of this, how do we get the money from him? Well, that's not how we do things here. He's not, this is not, oh, let me just find out, is he liquid? Can I get some money out of him? Nobody's proven the case yet, right? You can have all these allegations and say that he conspired with his father to do this. That's, for us, our position, that's completely ridiculous. So discovery is used for what you're alleging in your initial complaint. You didn't allege in your initial complaint that our client received any financial gain from this. You did not. So to say I want these documents and I want 14 years ago bank accounts, Your Honor, he just doesn't like what we provided him. What I would tell you, though, is we provide him over 200 pages of messages between father and son. And we provided documents. When he's calling Laura and says this guy owns 12 businesses, Your Honor, anybody can go on Laura. They are all named the same. What he meant is, I have 2 businesses, and yeah, I might have Metro Carpet, Metro City Carpet, but they're all one and the same. So we're not trying to obstruct. Mr. Turfy's actually been very kind with us. We've had a great working relationship. When he says, I'm here to sanction, and this is, in his own motion, he puts, this is a first-year law student would see that this is not sufficient enough. I'm not a first-year law student, and honestly, when I read this, you got a lot of documents here. You did 2 depositions. There's a lot of discovery. Like, what else are you looking for? Things that you're not going to find, and I understand, but you're not happy with that answer. So, Your Honor, we're willing to provide, and just so you know, Your Honor, when he filed this motion, or he actually sent an email and said, this is ridiculous, we followed it up by saying, hey, what else do you need? Tell us, can we be more specific? And he said, I'm not going to take my time to tell you that because this stuff is ridiculous. Like, so, come on, like, tell me what you're missing so we can go back and try to answer the questions.
Your Honor, may I respond?
Counsel, this sounds like a great referral to the Discovery Master so that they can sit down, see what you've produced, see what else you need, and I'm going to let them handle it. So I'm going to refer this to our Discovery Mediation Program, because as we sit here now, it sounds to me like if you guys talk to each other, you will be able to work it out and reach some sort of reasonable resolution, but I'm going to have you do that on their time.
Okay.
So I'm going to take this under advisement, refer it there, and then you guys will come back to me once you meet with the Discovery Master and she can go through, or he can go through the documents that are produced and see what's sufficient and what more you need, Mr. Turfy.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Thank you. Thank you both very much.
Bye-bye.
Miss Pearson, if you could send me the press fee, and I'll do the email to Miss Sykes. All right, Mr. Bazzi. Who's here on Bodrun? Is that you, Mr. Romer?
Yes, Your Honor. Hi, good morning.
All right. Good morning. Calling case number 24-012-036, Hassan Bodrun versus Farmers. Appearances, please.
Good morning to you and your staff, Your Honor. Nimi Bazzi, P84183 on behalf of the plaintiff.
Good morning, Your Honor. Nicholas Romer on behalf of defendant P76981.
Okay. All right. Go ahead, Mr. Romer.
All right, Your Honor. So this is our motion to dismiss. As the court may recall, we had filed a motion for partial summary disposition based on the 1 year back.
Yep, I remember.
And
basically what we're here for is, have they submitted any additional bills to you? The reason I set up for oral argument is that they said they had, and then I didn't see any sort of bills or any claims attached to their response.
Right, I agreed. And Your Honor, and the the backdrop here also that I think the court should keep in mind and be aware of, the guy was on the job, and so there's an open workers' comp claim. So workers' compensation is paying the medical bills, paid the 16 weeks of wage loss. Now there could be a potential excess wage loss claim, but that's barred by the 1 year back because it was just like 16 weeks, and this was a 2022 accident. So that's kind of the problem. We're like, I don't know why we're here.
I don't know why we're here either. Mr. Bazzi, you're saying you still have claims. Why haven't you produced anything to Mr. Romer or even the court in your response?
Well, Your Honor, I did have produce them in the case evaluation summary. There's a case there was a summary that
Okay, well, I think there was a court order that you had to produce them to counsel by May 2nd. And I see nothing attached to your motion. Okay, then what bills are you still claiming that you think are viable that aren't barred by the 1 year back rule?
I have one from Insight Surgical from Dr. Jawad Shah. Those are from September 4th of 2024, September 25th, and October 7th of 2024. There's also from Insight. There's multiple dates of service. Mainly Insight Surgical Hospital, Your Honor.
Okay, Mr. Romer, do you have those?
They were attached to our case evaluation summary.
I thought we removed the case from case eval.
We did, but I still submitted one to avoid the fee.
And when did you submit that?
The June 16.
Okay, so after May 2nd.
Correct.
Why? I mean, this shouldn't be that hard. What kind of bills are we talking here? What's the total of your bills?
I don't have an exact total. I can give you a rough estimate.
I mean, are you contesting that work comp is paying the medical bills? Like that's part of the problem. Like, do we have to file a separate motion? I mean, this is kind of well established that work comp is primary and pays medical bills.
I don't know the status of the work comp claim at the moment, but from, just from looking at it, there's like 1,500, about 3,000 from Insight. There's a pharmacy bill. There's like a few $100s just from one pharmacy bill. There's a befitting you for about 600. But as to the workers' compensation claim status, I don't have that at the moment.
Why does everything have to be so complicated?
Yeah,
this should have been very easy.
And I apologize, Jenna, because I received those after May 2nd.
Mm-hmm. Well, that was the issue, whether there were any outstanding bills. It sounds like there may be outstanding bills, but if they are barred by workers' comp, then it's pointless.
And if those dates of service are barred by workers' comp, I have no issue, stipulating to some kind of relief. But where I stand now, what I have in front of me is unpaid.
Do you want me to take this under advisement for a couple weeks and have you guys look into it and see if these are going to be barred by the workers' comp? I mean, it sounds to me like workers' comp is going to cover this.
Right. It's because the guy was on the job doing maintenance on a vehicle. And so workers' comp is primary. And we subpoenaed the workers' comp claim file in the case, and there hadn't been treatment for a long time. So I don't know if he just recently started treating again. It sounds like maybe, I don't know, but you got to submit those bills to workers' comp because they were paying everything. And I reached out to plaintiff's counsel's office at the outset of this case. I'm like, it's work comp. What are we looking at?
What are we doing?
Yeah. And so we've been litigating this case this entire time, and we've been kind of frustrated because it's like, well, workers' comp is primary, and there's this 1 year back issue that knocks out, the wage loss, any potential excess wage loss claims. So work comp is primary. I don't know what we're doing.
I don't know what we're doing either. Mr. Bazzi, you have the Insight bills. I don't know if those are related to the accident. It sounds like if they are related to the accident, they would be covered under workers' comp. but that's not the issue before the court. And I don't ever want to screw any side over, but my God, I give you opportunity after opportunity to bring the claims in a timely fashion. And I mean, you guys didn't even go to case valuation. You submitted a case valuation summary, and that's where you attach the bills rather than just supplying them to plaintiff's counsel. I understand that they came in late.
Yeah, no, we are
So-
going to facilitation
Go ahead.
on this matter as well too. So,
I'm sorry, Mr. Bazzi, I didn't hear you. What'd you say?
we opted out of case eval to go to facilitation, but as I stated, I wanted to avoid the late fee, so I submitted a summary. I can send over the summary to brother counsel today. And if the court can take this under advisement, maybe I can get the workers' compensation claim file as well. See what the status on the claim is, see if those bills are actually paid. I mean, if all the bills were paid and there's no more further treatment, you know,
That's the point, right? That's why we don't know why we're here. If workers' comp's gonna pay it, then this is pointless and it's a waste of my time.
but then we run into the issue whether or not workers' comp is not going to be paying this bill, then there's an outstanding bill that my client is going to be responsible for, and that was after the 1 year.
Well, your relief would be to pursue relief through the workers' comp tribunal.
All right, here's what I'm gonna do. Mr. Bazzi, get those bills over to him today. I'm going to deny this. If you have another motion based on any sort of workers' comp issue, bring it, Mr. Romer. But as of right now, he does have, or he claims he has bills that he did try to submit. They were, albeit late, but that's because I didn't want to delay anything more on this docket. For now, this is denied. Look over the bills. Send those to him. Honestly, I'm going to say if you don't send these by, this is what I'm going to do. Denied. However, if you don't provide the bills by Monday, we're dismissing this case because this is now becoming a waste of my time to keep giving opportunity after opportunity. What is Monday? Monday is June 30th. Provide the bills because I don't know if he has them in your case evaluation summary, but anything that you don't provide by Monday is out. And then, Mr. Romer, if you have another motion to bring based on the workers' comp issue, just bring it.
Okay.
That's how we're gonna handle it.
Can we just have him?
Thank you all.
Your Honor, can we just have him e-file the whatever bills that he's claiming so there's a
Yeah.
record of him producing it?
Yeah, absolutely.
Well, Your Honor, instead of doing that, because to protect my client's privacy, I'll either just send them over and file a proof of service that I sent them over. Would that be sufficient?
It would be. I mean, you can always redact whatever you e-file as well. But that's fine. Send them over and file a proof of service.
Okay, will do.
Yep. Mr. Romer, if there's any additional issues, this case is on my radar. So
Okay.
file the appropriate motions.
All right. I'll submit.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Nice seeing you.
Ms. Pearson, if you could send me that Prospe, I'll issue that today too. Ms. Webster Cox, what case are you here for?
Hi, Your Honor. Yes, I'm here for the Tyler Woods case, which I thought Brandon Heisman was going to be here because I was telling him that I'm going to go ahead and stipulate to dismiss the case.
Yes, well, we are already aware of that.
Oh, okay. I didn't
Yep.
know that.
No,
That's the only reason.
Yep, I was aware that that's being taken off the docket.
Okay. Did not know. He didn't
So
respond
you guys
back
just
to me.
submit an order.
Okay, perfect. Thank you. Thank you. Have a great
Thank you.
weekend.
You too.
Thanks.
Mr. Hansberry, what case are you here for?
Yes, Your Honor. I am here on a show cause for Elijah Tate versus State Farm.
Yes. Okay. Remind me, because that also wasn't printed up for me.
Yes, this was, the court had previously ordered for the plaintiffs to provide EOBs by April 16th. They provided some, but not all. There are still quite a few that are missing. There was a show cause hearing on June 13th. The court ordered that the EOBs produced by today or appear today by Zoom.
Okay.
Again, there's a few providers that we have some of them. There are other providers we don't have any. My request would be that the court just simply provide an order that any medical bills are stricken for which the EOBs have not been provided. I think the court has the power to do that under MCR 2.313 for violation of a discovery order.
Give me 1 second to pull this up.
Sure.
My issue is the language of the order, because if they were ordered to produce them or appear last week, I might have to give them an additional week just
Actually, I
to
can read it.
appear. So that's what I want to see. I don't think that your request is unreasonable. I can't ding them for violating an order when the order says a different date than what I provided. Here we go. Oh no, it's today.
Yeah, we are on the docket today.
Yep. Okay. No, it's today. I was just wondering if it was from last week and I ordered them to appear. Okay, let me call it. Calling case number 24-000677. Elijah Tate versus State Farm. Appearances, please.
Scott Hansberry on behalf of defendant State Farm.
Okay, we are here for a show cause hearing. This was ordered as of June 16th. Plaintiff shall produce the EOBs before June 27th. 2025 at 9 a.m. or appear in court via Zoom at that time to show cause why she should not be held in contempt. No one is here for plaintiff, and plaintiff is not here. So I think the appropriate relief is to bar any claims where the EOBs weren't produced before today's date. I believe you have those in your possession. So submit an order.
I will do that. Thank you, Your Honor.
Thank you very much.
Have a good weekend.
Yep, you too. All right, I'm going to stop the recording. Corey, I have a question for you, so give me a second.